dressed up fancy here today and left their barn boots at home. They might have been a lot of manure going around here. We saved the most exciting topic for last, the estate tax. You're probably hearing about it a lot in the news. It's part of this fiscal cliff that they're talking about all the time because, as Bob mentioned, we have a law that's set to reset itself if Congress doesn't reach a decision before the end of the year. So I'm going to give you just a little bit of, take a step back as to why is this such a big deal. It seems like tax issues change year to year. We're used to that, but just a little historical perspective, that hadn't been the case in the estate tax. But for some reason, since I started practicing in this area about 6 years ago, we've just been in this period of constant change. So I'm going to talk a little bit about where we've been with the estate tax, where we are right now through December 31 of 2012, and then where we're going, which it would be really helpful if I had a crystal ball to know that for sure. So historically, the estate tax was pretty predictable. We had an exemption amount, and this is going back to 1997, showing we started out at about $600,000 of assets that we could pass estate tax free, and that just gradually worked its way up, so that in 2011 that was at $675,000 of assets that we could pass without estate tax. Do keep in mind that these exemption amounts are per person, so if you're a married couple, you can in effect double that amount. Then the tax rate was also very predictable. The top rate was at 55%, and that was just a level tax. All three of kind of the taxes that come into play when we talk about estate taxes were all unified, and so there was just one magic number we needed to keep track of. So it was the estate tax, the gift tax, and then also the generation skipping transfer tax, which is when you try to skip one generation, pass down the assets rather than giving them to the kids, to the grandkids, hoping that then we only have to tax them once to eventually get there as opposed to twice. So they had another tax to grab you there to keep you from making that step. Then in 2001, there was a law passed that set up a system going from 2001 through 2009 that gradually worked up that tax-free amount over a period of years. So we started in 2002 with that amount being $1 million, and eventually getting up in 2009 to $3.5 million. That same law also worked that tax rate down over time. So we dropped down from that 55% down to 50%, and eventually worked our way down to 45%. It also, though, decoupled that system. So rather than just having that one magic number to keep track of, while that estate tax amount went up, the gift tax amount stayed at that $1 million. So it created different kind of planning ideas for us on whether we want to maybe give some farm assets during life, or maybe does it make sense to hang on to those and pass those at death through our estate plan, through a will or a trust. In 2010, that law was set to sunset. Now, I gave all kinds of these talks in 2009 saying there's no way Congress is going to let this law go away. There's no way they're going to give up this source of revenue of the estate tax. They're going to come to some arrangement. Whether that number is back at 1 million or up to 3.5 or something higher, they're going to come to some agreement. Because without congressional action, just as we're sitting here in 2012 going, well, if they don't act, things are going to change as of the end of the year. We were saying the same thing in 2009, except the change there was the tax completely went away. So in 2010, there was going to be no estate tax. You could be Bill Gates, you could be Warren Buffett, pass all of your assets, pay no estate tax. So we said, that's not going to happen, right? Well, it did. They didn't act. They let that estate tax lapse so that there was that unlimited exemption. And they actually didn't come to an agreement until the following December, almost the end of the following year. Kind of a topic that doesn't get talked about much with estate tax is we get really focused on that, how much can we pass tax-free? When that estate tax went away, they also took away a different tax advantage that comes with assets that pass at death. Typically, assets that you hold and that then pass at death get a readjustment of their tax basis or their cost basis. So if Grandpa bought the farm in 1950 and he paid $100 an acre, and now he still owns that farm and the land is worth $3,100 an acre, had he sold that acre of land during his lifetime, he would have paid capital gains tax on the difference between the $100 he paid and the $3,100 it was worth. So that $3,000 would be subject to capital gains tax. Grandpa still owned that when he died and passes it to son at his death. Son gets that acre of land at what it was worth when Grandpa passed away. So son gets that acre of land at $3,100, can sell it to the neighbor the next week for that $3,100, pay no tax. So Bob likes to call that the best tax law on the books. You just have to die to take advantage of it. I steal Bob's lines all the time, but since he's here today, I have to give him credit for them. So when that estate tax went away, they also took away that advantage of getting that step up in basis. So instead, they had a fixed amount that you could take that step up on. And there was a number for spouses, there was a number for property that went to other folks, but it created a lot of complications in estates as to whose assets get the step up, who gets that extra tax basis and gets to avoid that capital gains tax on the back end. So that's always my worry when there's talk about eliminating the death tax, is whether they would also eliminate that advantage of that step up in basis. Now keep in mind too, in Wisconsin, for husbands and wives, because of our marital property law system, the way that we own property as husbands and wives in Wisconsin, we actually get that advantage twice. We get it when the first spouse passes away, and again when the second spouse passes away, on all of the assets that are owned by marital property. And if you lived on the wrong side of the river, you lived in Minnesota, you only get that on that spouse's half of the property. And the difference is in Minnesota, they each own half the pie, the marital pie. In Wisconsin, we own the whole pie together. So it's semantics, but it makes a big difference from a tax perspective. So that's a huge advantage in Wisconsin that was lost when that system went away in 2010. They did eventually come to an agreement. They did it in December of 2010, and they gave, for those estates in 2010, they gave them two options. They could go ahead and have the unlimited assets pass with that modified step-up system, or they could use the new $5 million tax-free amount for estate tax purposes, rate of 35%, and you get that full step-up in basis. So we didn't have to mess around with, do these assets get a step up or don't they? So that was the 2010 rule. Then they created a 2-year window, and we're getting to the end of that 2-year window. So for 2011 and 2012, people who die in those years, they remodified those systems again, so we just have one magic number to keep track of, whether it's gifting or whether it's the estate tax. They set that tax-free number at $5 million. And they index it to inflation. So actually, as we sit here in 2012, the magic number is 5.12 million is our magic number. The 35% rate and that full step up in basis for those assets that pass at death. They also gave a new wrinkle that has worked really nicely for our clients, and that's the idea of portability. I mentioned that magic number can be doubled if you're married. It's whatever that number is for husband and whatever that number is for wife. The problem was in the past that if we had a pretty common plan for husbands and wives in their estate planning is, if one of us dies, give everything to the other, and then when we're both gone, give it to the kids. If we did that, husbands and wives can give as much as they want to each other. There's an unlimited marital deduction. So if we had, and I'll use 1 million as the magic number. So if the couple has $2 million, we should be fine, right? Because we should have $1 million for husband, $1 million for wife. Shouldn't have to worry about taxes. But if we have that plan where they each have their $1 million, but when the first spouse passes away, we're dumping their $1 million into the pot to the other spouse, now that surviving spouse has $2 million. And if the magic number is only $1 million, we have a problem. So what we did in the past was, when that first spouse died, rather than giving it to the other, we would say, Uncle Sam, tax me. Tax that $1 million. The tax due is 0. But now these are estate tax-free assets. And we'd set them over here in a separate pot, which was a trust, and we commonly call it a credit shelter trust, because we're guarding that credit, that whatever that magic number is, we're guarding that over here. And surviving spouse, you can use those assets. You can get access to them if you need them during your life. But if you don't, they're going to stay here. And then when the second spouse passes away, this pot goes to the kids, estate tax free, and we're only worrying about this pot. So we had to do some pre-planning to double that number. What this portability did was say, if we have that, dump the pot to the survivor. And so we haven't used any of that exemption amount. When the first spouse dies, you can file an estate tax return, say, carry that over to my surviving spouse. So if the magic number was $5 million in 2011 and spouses just gave everything to each other, we could still file that estate tax return and just say, you know what, that $5 million that husband didn't use, carry that over to wife. And so that's a huge advantage moving forward. If this number drops back down again, for couples where they had a spouse pass away during this time period, they still have that extra credit hanging out there in the wings. And we didn't have to do all that planning, setting up that separate trust in order to make sure that we get double that amount. But change is coming. In 2013, if Congress doesn't act before then, it's like pre-2001 all over again. So right now we're at 5.12. We're going to go back down to 1 million. That rate is going to go back up again to 55%. Good news is we do still get that full step up in basis, that value readjustment when those assets pass. And so this slide is kind of designed to show you, when they talk about that fiscal cliff, if you look at on the right-hand side of that slide, there's the cliff, going from that 5.12 back to that $1 million if they don't come to an agreement and make a change in the meantime. So we're in an unknown world. We're speculating what's going to happen. Obama has said he would advocate a $3.5 million exemption amount and a 45% top tax rate. Romney has talked about eliminating the death tax. And again, that sounds great in theory. I worry what that means for that step up in basis, because often that can be as big of a planning tool for many of my clients as being worried about that estate tax. And really, as we sit here today, we really don't know. We don't expect anything's going to happen between now and the election. The hope would be that they make a change between the election and the end of the year, so we actually know before 2013 is here what those rules are going to be, and help our clients make decisions about whether they should be doing any year-end tax planning. Tammy talked about that from the income tax side of things, but probably this year more than any year, we're really considering with people perhaps making some changes, doing some estate tax planning yet here in 2012. So what can you do? We're really, on the plans, we're trying to focus on flexibility. We've been reworking, I talked about doing that trust, doing that split when the first spouse dies. We're playing with how we determine how that split happens. If you have an old will and you have that estate tax planning in it, it's a good time to pull that out and look at it. Because the law had been so stable for so long, some of them actually have dollar amounts. Some of them say put $675,000 in that trust. Well, that's an outdated number now, and we actually don't know exactly what that number is going to be. And so utilizing formulas that will adjust to depending on what the law is at the time, or funding things by disclaimer, more of a wait and see approach as to what, if anything, we would put in that other trust. And important, even if you don't have a taxable estate, if someone passes away yet this year, filing that estate tax return, checking that box to get that portability. Because if we go off that cliff, and it is 1 million next year, potentially we could turn that 1 million into 6 million by carrying forward that exemption from the other spouse. Another strategy is to gift now. Gift before January 1 of 2013. If you have a sizable estate, you're worried about those estate taxes, we know as the law sits today that you can gift 5.12 million of assets, each spouse, without paying any gift tax. Now there's a concern if that number goes back to that 1 million again, whether they might claw some of that back then when it becomes estate tax time. But certainly what we've done is we've gotten those assets transferred now. We've also then gotten the appreciation of those assets. So if that land's worth $3,100 right now, and it might be worth $5,100 by the time you pass away, that $2,000 an acre we've protected because it's already been gifted, and now that's appreciating with the next generation rather than in your estate. As I said, lots of changes to come. This is my contact information. Don't hesitate, and we'll take some questions here. I think we'll have a little time for questions of the panel. But if you have issues, if you have questions about your specific situation, don't hesitate to give a call, send an email, or I'll be hanging around here afterwards also. Thank you.